This is because these documents include certain averments or statements as to Mr. Gabriel or Ms. Caffrey that were not relevant to this particular matter, and that could have tainted the Commission as to any potential future matters that would come before the Commission. I am the only Commissioner to review those documents, and I would abstain as appropriate from any such matters. Mr. Chair, I would suggest that this would be an appropriate time for any interested parties to speak on this matter. I would suggest that the comments of any interested party must be strictly confined to the limited issue of whether Mr. Gabriel has legal standing to appeal advice of counsel 10-624.
Is there anyone who wishes to address the Commission? Thank you. Would you be kind enough to state your full name, any title, and a business address?
Sure. My name is Megan Jones-Rolla. I'm here on behalf of Susan B. Caffrey. My business address is 600 Grant Street, Suite 4850, Pittsburgh, PA 15219, and I'm here as her counsel. And if I may proceed.
Thank you, please.
Sure. And also, too, I want to point out to the Commission, Ms. Caffrey is here to answer any questions should that need arise. With respect to what Commissioner Volk put forth, I think that the threshold issue is whether or not Mr. Gabriel has standing to appeal the advice of counsel. I think that PA Code 51, Section 13.2G is very clear that he does not have standing to do so. He is neither the requester nor the subject of the request, and furthermore, he's alleging that he has standing as a South Fayette Commissioner. However, South Fayette, this has never even been discussed at a South Fayette Commission meeting. No one has authorized him to do so, and again, the appropriate persons that would have been able to appeal the advice of counsel are Mr. Hoy or Ms. Caffrey, and neither party has chosen to do so. And I understand that that's the threshold issue that you really need to determine at this point. I have also, as Commissioner Volk pointed out, supplied a memorandum of law in favor of the advice of counsel, but looking at your agenda, it appears that that's not going to be considered today, that the only matter that will be considered is whether Mr. Gabriel has standing.
That's correct.
Okay, if that's the case, then I clearly won't go into the arguments regarding why the advice of counsel should stand.
Thank you very much. I'll leave it to you, counsel. Does your client wish to make any statement or not?
I'll just make myself available should you have questions.
You're so fortunate to have such a good attorney representing.
I picked them well.
Any members of the Commission have any questions for counsel or the client? Seeing none, Ms. Bergen? Mr. Volk, I'm sorry.
Mr. Chair, I've reviewed the facts and the relevant statutory provisions. I would note that Section 13.2 of the Commission's regulation provides, in pertinent part, that, quote, an advice of counsel may be appealed to the Commission by the requester or the subject of the request, end quote. In the instant matter, the requester of the advice was Mr. Hoy. The subject of the advice was Ms. Caffrey. It is my view that Mr. Gabriel does not have legal standing under Section 13.2 of the regulations of this Commission to appeal Hoy advice of counsel 10-624 because he is not the requester or the subject of the advice of counsel or the authorized representative thereof. As for Ms. Caffrey's request for attorney's fees, this Commission lacks legal authority to award attorney's fees. Based upon my analysis and comments, I would like to make the following motion. I move that the holding of this Commission in this matter be as follows. Mr. Gabriel does not have legal standing under Section 13.2 of the regulations of this Commission to appeal advice of counsel 10-624 because he is not the requester or the subject of the advice of counsel or the authorized representative thereof. Ms. Caffrey's motion to quash Mr. Gabriel's appeal of advice of counsel 10-624 is granted. The appeal of advice of counsel 10-624 is dismissed due to Mr. Gabriel's lack of legal standing. Ms. Caffrey's request for attorney fees is denied.
With that motion, is there a second?
Second.
And the floor is open for any comments, questions, concerns from any commissioner. There being none, all those in favor of the motion kindly respond by saying aye. Aye. Are there any opposed? There being none, the motion carries. Thank you very much. Ladies, thank you very much for appearing. With that, moving on to the agenda to the civil penalty orders. There are a number of them, and I think Commissioner Bolger, you have reviewed those as well. No, we're on Gottschalk, the civil penalty order.
Okay, I got it. Okay, this case involves civil penalties proceedings against respondent Sherma Gottschalk, a council member for Portland Borough, who filed deficient statements of financial interest, which I shall hereafter refer to as SFIs, for calendar years 2005, 2006, 2007, and 2008 with Portland Borough. The investigative division instituted formal proceedings against Ms. Gottschalk by filing with this commission and serving upon Ms. Gottschalk a petition for civil penalties. An order to show cause was issued to Ms. Gottschalk. Ms. Gottschalk did not file an answer to the order to show cause or request a hearing such that the factual averments of the petition for civil penalties were deemed admitted and a hearing was waived. On October 22nd, 2010, the Commission issued Gottschalk Order Number 375S. We determined that Ms. Gottschalk, as a council member for Portland Borough, failed to comply with Sections 1104A and 1105 of the Ethics Act when she filed deficient SFIs for calendar years 5, 6, 7, 8 with Portland Borough. We ordered Ms. Gottschalk to pay 4 maximum civil penalties for a total civil penalty liability of $1,000. We further ordered Ms. Gottschalk to file complete and accurate SFIs for calendar years 5, 6, 7, 8 with Portland Borough by no later than the 30th day after the mailing date of our order, with a copy of each such filing forwarded to this commission for compliance verification purposes. On November 22nd, 2010, we received Ms. Gottschalk's request for reconsideration of Orders Number 375S. On November 23rd, 2010, we received copies of Ms. Gottschalk's amended SFIs for calendar years 2005, 6, 7, and 8. In the request for reconsideration, Ms. Gottschalk claims inter alia that the only monetary compensation she did not disclose on her SFIs was funds in the amount of $450 per month that she received from an individual who lives in the upstairs of Ms. Gottschalk's house, that such funds were payment for expenses and not rent, and that she did not consider such funds to be income. Ms. Gottschalk further claims that she did not respond earlier to the proceedings against her because she was one of 3 caretakers for a terminally ill relative and because of personal medical reasons. The investigative division has filed an answer opposing Ms. Gottschalk's request for reconsideration and asserting that Ms. Gottschalk has failed to meet her burden of proof for establishing any need for granting reconsideration. In considering whether to grant reconsideration, I note that Ms. Gottschalk was clearly given an opportunity to file an answer to the order to show cause, request a hearing, and otherwise participate in this case, but she chose to do nothing. Based upon my review of this case, it is my view that Ms. Gottschalk's request for reconsideration fails to meet the requisite standard for reconsideration. Ms. Gottschalk has not alleged or established that a material error of law has occurred and no material error of fact has been established. No new facts or evidence has been provided which could not be or was not discovered by the exercise of due diligence, and that would lead to a reversal or modification of Order Number 375S. I believe that Ms. Gottschalk has failed to meet her burden of proof to establish any need for reconsideration. Based upon my analysis and comments, I would like to make the following motion. My motion to this commission is that I move that the commission deny the request for reconsideration of Gottschalk Order Number 375S.
Is there a second to the motion? It's been seconded. The floor is open for any comments, concerns questions? Ms. Hickey?
Mr. Fryman, just so the record reflects, there doesn't appear to be anyone here to speak on behalf of Ms. Gottschalk.
Which is accurate, and I will call just for the sake of it. Is there anyone here interested who wishes to speak, or is Ms. Gottschalk present and wishes to address the commission? There being no one present and no request to address the commission, since there has been a second, I'll ask for all those in favor of the motion to kindly respond by saying aye.
Aye.
Are there any opposed? And there being none, the motion carries. Next matter on the agenda, Commissioner Bolger, I believe you have that as well, civil penalty orders by default.
Mr. Chairman, there are 2 civil penalty default cases that are now before this commission for. These cases involve respondents Jeff Munley as a member of Archibald Borough Council and Dean Kinstner as a member of the school board of the Conrad Weiser School District. These respondents did not file timely answers or respond to the civil penalty proceeding. Following review, it is my opinion that as to each of these respondents, the commission should levy a maximum civil penalty $250 for each delinquent or deficient statement of financial interest. For Representative Munley, who failed to file 2 statements of financial interest, the total civil penalty liability would be $500. As to Respondent Kinster, who filed a deficient statement of financial interest, the total civil penalty would be $250. It is my opinion that the commission should also order the respondents to file or amend their statement of financial interest. There is nothing of record that would constitute a defense or excuse for their non-compliance. Based on this, I would like to make the following motion. I move that the commission level civil penalties against the following respondents, totaling the following amount for failing to file the statement of financial interest or for filing deficient statements of financial interest as follows. Number 1, Jeff Munley, a total of $500 for calendar years 2007 and 2008. Number 2, Dean Titsner, $250 for calendar year 2006. Further, these respondents shall be ordered to file or amend their statements of financial interest for the years stated within 30 days of the issuance of the commission's order.
With that motion, is there a second?
Second.
And there is a second. The floor is open for any comments. There being none, all those in favor of the motion, please respond by saying aye.
Aye.
Are there any opposed? There being none, the motion carries. And with that, I think there's one consent. Mr. Bolger, if you would go through that with us.
Yeah, I just moved that we adopt, well, I'll read.
I don't think you have to read the whole thing. We all have the information to read it, but let's just give what the case is and the number, and then we can take it from there.
Okay, the
Calicut case, civil penalty
order
order number 10-032-P.
right. And I move we adopt that order.
All the commissioners have been supplied with this information and the consent decree. There's a second by Mr. Calafell.
And it's a consent, so.
With that, are there any questions concerning the consent order or for Mr. Contino? There being none, all those in favor of adopting the consent, kindly respond by saying aye.
Aye.
Any negative-minded? There are none. It will be approved. Going into the lobbying portion, there are civil penalty orders also by consent. And I believe, Commissioner Volk, you've looked at these, as have we all.
Yes, I have, Chair. There are 2 administrative penalty cases with proposed consent agreements for our consideration. The first respondent, RJ Properties Group LLC, failed to timely file quarterly expense reports for the 2nd, 3rd, and 4th quarters of 2009. A warning notice was issued to R&J, but R&J did not cure its noncompliance during the grace period that was provided. The parties have agreed that these expense reports were a total of 1,074 days delinquent. The other respondent, the Goldenberg Group, failed to timely file quarterly expense reports for all 4 quarters of 2007 and the 1st quarter of 2008. A warning notice was issued, but the Goldenberg Group did not cure its noncompliance within the grace period that was provided. The parties have agreed that the forms were delinquent by a total of 165 days.